Coming up in all angles, lice and Junjo, Junjo and lice, the Supreme Court ruling that has everyone talking, the Kensington primary school case and the dreadlock child.
Everybody have the right to do, as long as they are doing anything in the ambit of the law.
We'll be breaking down the ruling and looking at the wider implications. Much for joining us for another edition of the program, and as always, welcome to our viewers on onespotmedia.com. And remember, our hashtag is TVJ All Angles. Now, in studio for this section of the program, we're going to be talking to attorneys Jodianne Quarry. Jodianne, of course, also part of the RGR Gleaner Group family as one of the hosts on our morning agenda program on Power 106. And attorney Clyde Williams is also with us. Now, a little bit later on in the program, we're going to be hearing from some educators in terms of current attitudes to hair and rules are rules and so on. Before that, though, here is a little bit of an overview of the Kensington primary ruling that has been creating such controversy. Lice and Junjo. Junjo and lice, they figure prominently in the case of Virgo against Kensington Primary School. The case where a primary school told the parents of a child with dreadlocks to cut her locks for her to be admitted to school. So how do lice and Junjo figure? She was accepted to start September 2018. At orientation, the school told the mother there was a policy of no braids, no beads, no locking of hair. The child, through her mother, claimed the breach of her rights to freedom of expression, equality before the law, measures of protection required because she's a minor, publicly funded tuition in a public educational institution at pre-primary and primary levels, the right to enroll in and attend school, the right to equitable and humane treatment by any public authority, and the right to respect for and protection of private and family life. So fast forward to the Supreme Court's unanimous ruling. 3 judges all agreed. The child's father, Dale Virgo, had claimed his rights were breached as well, but the court said he had no standing in the case, saying he had not shown he had been personally affected by the policy. The court made a point of saying this was not a case of Rastafarians being prevented from having their child attend a public institution, as that issue has long been settled. The judge said this was about a right to individual expression of a conscientiously held belief based on a decision taken by an individual and their family. In other words, how far should the school and or the courts go in endorsing this extent of freedom of expression in light of rules and regulations for uniform and adornment laid down for public schools? The court held none of the child's rights had been breached. 2 of the major issues, the schools claimed that its policy was necessary to prevent outbreaks of lice and Junjo. Yes, those words again. The court accepted the school's assertion. At paragraph 94, the judge said there is no dispute that the school established this policy not as a way to maintain discipline and order, but as a preventative measure in the case of an outbreak of lice and Junjo. It's clear from the evidence the school had sanctioned this policy on the basis of its own experiences with unhygienic students in the past. And at paragraph 122, the school, through its then principal, indicated her locks are prohibited, as there is a possibility that the hairstyle would lead to a lice or Junjo infestation. It's my view that hygiene is a legitimate aim. Another important point in the ruling, freedom of expression. The court said the right to freedom of expression encompasses any form of expression used to communicate a particular idea, including hairstyles worn with intent. The court said in part, schools can't survive without rules. We're certainly allowed freedom of expression, but schools can't be left to guess what it is if it falls outside of set rules, guidelines and norms, and added that it can't be right or just for each individual to vary the rules of engagement with these organizations simply on the basis that it doesn't fit in with their choices and mode of self-expression. Now, The courts also use the floodgates analogy, with the judge saying, I'm wary of opening what may be considered the floodgates of self-expression. This may mean that a student or their parent could wake up tomorrow and identify as whoever or whatever animate or inanimate object or personality they wish, or identify themselves with any belief, and come to school expressed that way in pursuance of their right of freedom of expression and a decision taken in the home. Finally, the judge suggested that perhaps it's time for Parliament to intervene and take away the matter from the discretion of individual schools and give it the force of law. Okay, so I'm going to start off with a question that one of our crew members just asked me. So Jody, and let me ask you first. Because one of my cameramen said to me just now, this don't make no sense. Why can't a school decide that it doesn't want to admit a student? Surely that's why we appoint principals, we appoint boards to run the school. What's wrong with that?
Some things can be within the remit of a principal to decide. Some things can't be. If you're going to violate the Constitution in your decision-making as a principal, and it should be part of a broader strategy, a broader policy, something that the Ministry of Education should decide on, you should have rules about at a higher level, then it can't be the principal's feelings or discretion that guides that. Some of these things have to be outside of the purview of the decision-making of the principal because they just don't know enough to prevent there from being a whole constitutional challenge about it.
Except that the judge said, I find the policy of the school did not violate the child's right to education. She does not have a right to attend a particular institution. Kensington Primary can reject her as a student. She can always attend another school that supports her form of expression. That sounds like the opposite of what you just said.
It is the opposite of what I've just said. This is a government-funded school. This is not a private school that you can decide if you must go or not. If the government of Jamaica is going to defend that claim, if the government of Jamaica is going to give public funds to a particular school, then you are not in a position to allow this child to go to X primary school, but not Y, because of the women fancy of a principal and the administration. Why women fancy? Because the current administration, when the former principal, who was the reason for this case, left, has said that it has changed its position completely. You cannot allow children's educations and any child to be at the whim of anybody who feels, based on a particular day or their own particular view of the world, that a child should or should not have access to a school because of their hair.
You're saying the judge is wrong?
I'm saying I disagree with the decision and how we got there, because the judgment doesn't give me some information that I need. The judgment doesn't tell me that it has prioritized the rights of the child. This case is not about Kensington's decision not to let in, about the rule that Kensington had. It's about a child being affected by a decision taken by the school. And so the priority must be the child. What is it that we need to think of when we think of a child and a child's rights? What special rights do they have? And I don't think that the case did enough of that to help me understand the decision.
Clyde, another thing people have been saying is, again, why the big deal? Because the court, the judge especially said, this is not about Rastafarians. We have long agreed and settled that the children of Rastafarians can go to school with locks. So if that is not an issue here, what not carry on about?
But it was an issue because the school said you will not be allowed to start in September if you have your locks up. You'll have to cut the locks.
Except they said if you're a Rasta, though, and you did tell us say you're a Rasta, this is what the court has said, then should have been allowed in.
Yes. However, the freedom of expression was one of the biggest issues in the case. And the question that was raised by the claimant's lawyers was whether or not the infringement of the right to wear a dreadlock, a locked hairstyle, whether that infringes on the right to express one's self. That was a central point. Now remember, the school said we are doing this to this end, a hygienic end, they said, and so on and so forth.
To prevent lice and junjo.
That's right. But there is no evidence that the court dealt with in the judgment that established that there was in fact this problem at the school and that the measure that they introduced was proportionate to the right in terms of restricting the right.
First of all, what you mean? Because what the court said is that the school said we've had this problem in
But
the
there
past.
is no evidence. You can't assert something. That's not evidence, that's an assertion. Evidence is when you bring information to the court, such as we have had 500 cases of lice infestation in the school over the last 7 years, whatever it is. None of that was said. They merely said that they did this for. Contrast this with the evidence given by the mother about the Nazarene vow. Evidence is given by the mother about the Nazarene vow that the child is grown up that way. But then the court says that there wasn't sufficient evidence before it about the Nazarene vow. So you say to yourself, what do you mean? The child is 5. The mother says, I grow my child this way. The child has a locked hairstyle, consistent now with what the mother has said about the Nazarene vow. How is that not sufficient evidence to make that a live issue that you can see that there is an expression of a Nazarene vow in the hairstyle? That's what the judge said. But then the judge readily accepted, without any evidence, an assertion about lice and jonjo. I would be appealing this like I read judgments 3 times before I settle grounds. When I read this for the first time, and just for listeners to understand, judges make errors. It's not personal. When lawyers lose cases, they go to the next level if they think the judge erred. So it's normal in our business to say a judge has erred, respectfully. And then we appeal. By the end of the first read, I had already settled 2 grounds of appeal. One, relating to the expression, to the meaning of freedom of expression. The judge narrowly construed freedom of expression to mean that you must have an idea or a belief that you wish to communicate, rather than a broad, all-embracing one that entails and encapsulates how you dress, how you feel. So I can wear a shoes without any idea, or a woman may wear a dress, a color, without any idea to communicate. But she feels good about it. She likes how it feeds on her.
So it's that expression.
That's expression.
If I wear a purple shirt and I am not Casey,
Yes.
just because I like purple.
That's your expression. That is part of the autonomy, the independence of your personhood, that you're expressing it. You don't have to have a reason.
Except the judge say school can't run so.
How?
Schools have to have rules and regulations, and you can't just get up and want to wear purple when the school uniform, my words, viewers, not the judges, when the school uniform is khaki and green and white. Nothing can run
before
so.
Jody jump in, I want to say this very, very quickly.
Oh, you're seeing her getting ready?
No, but Jody has a lot to say on this. I want to say this very, very quickly. The judge and the court started it in the wrong place. They didn't say, are these rules infringing, abrogating, and abridging the right of the child to these things? They start by saying, how do we accommodate expressions of a child? That's the wrong place to start.
Say that again.
So they did not start at asking whether the rules, unwritten rules, whether
Can be
those
justified.
rules infringe the rights of the child. They didn't start there. The court start by asking how the courts and the school must extend themselves to deal with the right. That's the wrong place to start.
Hold that point, because we've got off to a start, but I have to take a break, so we come back and pick up when we come back. Remember, our hashtag is TVJ. All angles soon come.